am Stephen Gold, the author of The Return of Breaking Law.
All rise, if you're able.
That is what ushers in law courts and tribunals will now be shouting out to the assembled lawyers, litigants, witnesses, reporters, and anyone else who's popped in off the street to keep out of the rain and hear some real-life drama. And they'll be shouting it out as the judge or magistrates enter the room. Out of respect, all should then stand, if able. That's the point. If unable to stand, they could feel embarrassed or even force themselves up when they shouldn't be doing so. That's why the announcement by ushers, which has been...
All rise.
...is being changed to...
All rise, if you're able.
The thing about the Financial Ombudsman Service is that it's free, well, most of the time. We'll come to that in a moment. So, no court fees, no attendance, decisions on complaints are made on paper, you see. If you're sensible, you've got an aversion to the idea of making a county court claim, and you prefer not going out, the Ombudsman could be for you, whether you have a grouse about a scam, a bank, a shop, your pension, insurance, PPI, secret commission, even a prepaid funeral plan. Two things to tell you about the service. Although it is free to you as a consumer, if a claims management company or some other professional puts in the complaint on your behalf, a charge will be made, and that's as from the 1st of April of this year. And that will no doubt be passed on to you by the professional. The charge, well, generally £250, but £175 of that gets refunded if a complaint is successful. Do it yourself. In fact, figures provided to me show that the success rate for complaints made by professionals is lower than that for complaints made by consumers in person, 26% as against 38%. And the other thing is that the Financial Ombudsman Service now takes complaints by small businesses, not just consumers. 99% of UK businesses qualify as small for this purpose. Again, the service is free unless the business's complaint is put in by a professional.
It sounds too good to be true. Any disadvantages?
Well, you don't get a chance to swear at your opponents, only in writing. But seriously, if there is a major dispute on some facts, what actually happened, there's no opportunity to cross-examine as you would have in court. That's a disadvantage. Against that, a very handy service if you're not overconfident that you would win in court, and particularly useful for lower value complaints.
If the Ombudsman is against you, can you still go to court?
You can. So you've got a tax bill and other bills to pay, and you were hoping for a day out in Bognor Regis. Let the tax bill ride. After all, you saw the taxman through the office window and he looked quite cuddly. He even smiled. Not at you, and very quickly. Perhaps it was more of a twitch than a smile, come to think of it. Anyway, in deciding in which order to settle your debts, bear this in mind. Not paying taxes on time will cost you interest and may cost you penalties on top.
So what's the damage for late payment, Stephen?
Well, the interest rate on the main taxes and duties rose to 8.5%. That's 1.5% up, as from the 6th of April 2025. But late payment in the absence of a time to pay agreement with the taxman will cost you a penalty on top of the interest. The penalties are changing as from the 31st of May 2025. No payment after 15 days, a lump sum of 3% on what you owe. That's up from 2%. No payment after 30 days, another lump sum of 3% on what you owe, up from 2%. And there's another penalty after 30 days until you pay. That is at a daily rate of 10% on what you owe, and that's up from 4%. You still standing? Interestingly, if you'll forgive the pun, the current interest rate on what Revenue and Customs repays to you, the taxpayer, or non-payer, when they refund money to you, which occasionally can happen, is 3.5%. Just saying. The official line is that the 3.5% rate compares favourably with commercial practice for interest charged on loans and overdrafts and interest paid on deposits. Burial or cremation? Do you have a preference? If you do, where do you express it? And can your wishes be ignored? In a case just before the High Court, a man born in India who'd lived in England for around 70 years up to his death had made a will, which is the best and most obvious place to state what you want to happen to your body on your death. However, he was silent in the will on this subject. He appointed his daughter, who'd been his carer for some time, along with his son as his executors. Now, it's the legal duty of executors, or administrators who do the same job as executors where there is no will, to arrange for the proper disposal of the dead body, which is what the daughter and the son set out to do, but they couldn't agree between them what should happen to their father's body. Daughter wanted her father to be buried in India. Son favoured cremation and the scattering of ashes in accordance with Hindu funeral rites in England. Well, someone had to settle the dispute. This responsibility fell to a judge of the High Court, for that court has jurisdiction to perform that task. The court looked into what had been the wishes of the deceased man. There was such conflicting evidence on this that the judge couldn't say one way or the other. But, stated the judge, though those wishes were something to be taken into account, they wouldn't be conclusive. In this case, the wishes of the wider family had great weight. Their needs, said the judge, were the needs of the living. It was they who would attend the funeral, and they had to grieve and remember. The daughter was the only family member who argued for India. The decision of the judge was that the body should be cremated and that the ashes should be scattered in England.
So what you say in your will can be ignored by the court?
Well, as this judge stated, it will be taken into account what wishes are expressed, but they may not be followed if there are some good reasons to order something else. The moral of the story is, firstly, if you have a wish, put it down in the will. Secondly, give any particular reasons for the wish so that those reasons, as well as the actual wish, will be known to a court in the event of a dispute, which, unless crazy, will make it more difficult for the court to depart from what you said you want to happen.
I can't let this video come to an end without mentioning that this is your 50th Law Watch video. So congratulations, Stephen. I suppose we could call it a gold anniversary.